This is Colin O'Keefe with Thursday's episode of LXPN TV. The Iowa football program is coming under a bit of scrutiny for gender discrimination due to its all-pink visitors' locker room. Joining me to explain what's happening and why, though it's somewhat ridiculous, the story can't be quickly dismissed, is Patrick Smith, attorney with Bradshaw, Fowler, Proctor, and Fairgrave in Des Moines and author on the Iowa Employment Law blog. Patrick, first, can you explain the background of this claim? Who's bringing it and why?
Sure. Yeah, thanks, Colin, for the opportunity to speak today. It's not a legal claim as such right now in the sense that it's been filed in court or with an agency. But what happened is a couple of weeks ago, Jill Galder, who's an attorney in Minnesota, runs an advocacy organization called Gender Justice, was giving a speech at a conference, and she brought up the pink locker room as something where an educational institution was discriminating against women. And there's a law called Title IX of the Civil Rights Act. It's similar to Title VII, except it governs educational institutions. And she contends that that locker room violates that law. It's interesting that this Ms. Galdo used to be a professor at the University of Iowa Law School. And according to information on her website, she was involved back in 2005. Kinnick Stadium was renovated, and there was a debate: do we keep the pink locker room or not? And she was involved in some protests and activities to try and get rid of the pink locker room. And ultimately, the university decided to keep it. And so she has a bit of a history with the pink locker room and advocating against it. But around these parts, it's kind of legendary. Coach Fry, anyone who follows college football, associates him with the resurgence of the program back in the 80s, and that pink locker room is closely associated with that.
Absolutely. I know I've heard of the pink locker room just being a college football fan, and I know its reputation has spread throughout the country. And second, you wrote that though it's somewhat ridiculous, this story, it can't be easily dismissed. Why is that?
Yeah, when I started the blog post, it was intended to be kind of a tongue-in-cheek exercise to kind of poke fun at this. Obviously, we have a lot of Hawkeye fans around here, many of whom are women, and there probably aren't too many of them who would think of Coach Fry or the University of Iowa, for that matter, as intending to discriminate against women. But nonetheless, as I said, we can't write it off completely for a couple of reasons. One is in our circuit, the Eighth Circuit, the courts have recognized that a person can bring a claim for sex discrimination based upon gender stereotypes. That is, if they act in a way that doesn't conform to their gender, it may violate the law. The classic example being if you have a female employee who has masculine characteristics or a male employee with feminine characteristics, if there are employment decisions made because of that, that can violate the law. And so that's a legitimate concern employers ought to have, and I think that's a concern of Ms. Godler as well. So that's really the main thing I wanted to point out, despite my emphasis at tongue-in-cheek.
Absolutely. It's kind of a goofball story, one that you'll see from time to time, but as you mentioned and as you wrote on, it's one that there are some lessons from, and it can't be easily dismissed. Again, that was Patrick Smith of Bradshaw, Fowler, Proctor, and Fairgrave. For more of his insight, be sure to visit iowaemploymentlawblog.com. And as always, visit us at lxpn.com for hundreds of these LXPN TV video interviews, along with curated commentary from the Lex Blog Network's more than 8,000 members. Thanks for joining us today, Patrick.
Great. Thank you, Colin.